Good day everyone and welcome to NQA Law Channel, your legal ally, where we share relevant information for your daily protection. This is our episode 8. It's the second week of the Love Month and our next episode will be focusing on one question coming from my good friend, Sarah. Shout out to Sarah and thank you very much for this question. Her question is, will a live-in relationship result to inheritance? In other words, kung dugay na kamo ga live-in sa imo partner, kung may mauna sa inyo, may makuha bala nga mana ang nabilin nga live-in partner? That is our question for the second week of this February or the Love Month. So let us make it very clear. How does a live-in partner inherit? There could be two ways. Number 1, you may designate your live-in partner in your last will and testament. In other words, by being a voluntary heir. Still subject though to legitims or rights of legal heirs. Secondly, pwede man through proprietary or property dispositions before death, such as sale, donation, assignment of rights, and the like. So, pwede gijapon ka share sa property basta ginplanuhan lang ahead. If it's your choice not to marry each other, you can still take control of your properties that you have, of course, pulled in through your joint efforts. Para fair man. In other words, love plus length of time contained within living in or cohabitation without marriage does not equate to inheritance if one of you passes away. But what is the exception to this? So there might not be inheritance rights, but there could be proprietary or property rights. Even the Family Code of the Philippines recognizes this. You may review Article 147 and 148 of the Family Code for this matter. So, if ever ang mag-live-in partner may ara sila be joint contribution in a business or may ara sila be co-ownerships, there could be sharing in property rights. So, hindi na siya inheritance rights, but rather property rights. So, the short answer is no. By mere live-in relationship alone, you cannot inherit from your live-in partner who passed away ahead of you. In other words, kung naga-live-in ka mo sa imo nga partner, hindi ambot silingon nga bisan ano pa kadugay ang updanay ninyo, may kuhaon ka sa iya nga mana. Under the Philippine laws, by operation of law, only compulsory heirs are able to inherit from somebody who died. In other words, iya lang legal spouse, children, illegitimate children, ascendants and descendants as the case may be. It is not enough nagapalanggaanay ka mo, kaglawig ng iniupdanay, nga makapamato ka nga may ara ka kuhaon sa nabilin na propiedad sang imo live-in partner. So there you go, Sarah. I hope we have answered your question to your satisfaction. Thank you very much, everyone, for watching. This is Attorney Nea of NQA Law Channel, reminding you once again to know your rights and know your limits. See you in our next episode. Once again, we are reminding our viewers that this is only for general information, not legal advice. For more clarity and for more precision, please see your lawyers. Thank you and God bless everyone.